Mr. Smith, we'll call the 1-6 case next. So we're on the record in docket 20-1604347. That is the city of, that is Lafque versus Narani Musa. Will the parties please introduce themselves for the record? Mr. Smith.
For plaintiff LAFCU, Tim Smith, P48259. I think it looks like Mr. Narani Musa logged out after our breakout room, but I can fill you in on what we discussed and what we're doing moving.
All right. All right. This is the time and place for, this is a discovery motion. And to make the record, Mr. Smith, you did have the opportunity to speak with Mr. Musa previous to this event in a breakout room. And are you waiving his appearance today based on that meeting?
I am, Your Honor. We completed the Q&A
All right.
part of the creditor examination. There are some documents, though, that are responsive to your subpoena. I confirmed his mailing address. I'm going to get in writing to him, reminding him what he needs to get to my office. He agreed that 30 days was enough time to do that. Perhaps if we simply set a control date 30 days out, I anticipate compliance. If I get the documents, I can call and cancel that. Otherwise, he and I can come back and he can explain why he didn't produce.
All right. So we'll anticipate compliance with the discovery proceeding. And you had the opportunity to meet with Mr. Musa, and we'll set a control date.
October 23rd at 8:30.
October 23rd at 8:30 for this control date for the file, and then you'll let us know if we need that hearing date or not. Is that a fair statement, Mr. Smith?
Absolutely, Your Honor.
All right. Anything else for the record in 1604347? You have that October 23rd date at 8:30.
Correct. Nothing more for the record, Your Honor. Thank you for your help.
Thank you. And then, Mr. Smith, if you give me. Mr. Sarhan, are you here for LVNV funding or Winona Smith?
On behalf of plaintiff, Your Honor, LVNV funding.
All right. All right. Give me 1 minute and we'll call that case. All right, Mr. Sarhan, I think we can call that case. We're on the record in docket 23-02536. That's LVNV funding versus Winona Smith. Will the parties please introduce themselves for the record? Mr. Sarhan.
Good afternoon, Your Honor. Alexander Sarhan, P77252 on behalf of plaintiff.
All right, this is the time set for the motion to set aside a dismissal. I do not see Winona Smith in the Zoom courtroom. I do not see Winona Smith in the physical courtroom. I'm going to call the hallway And then I'm going to go ahead and look at how this was filed. This was a motion to set aside dismissal. Is this filed by yourself, Mr. Serhan? It appeared that I dismissed this for neither party appearing.
That's correct, Your Honor.
All right.
The defendant was
so
represented by, I'm sorry,
go ahead.
defendant was represented by counsel.
All right. So the defendant was represented by counsel. I have Ogletree as listed on here.
That's correct.
And then I have McKinnon for LVNP. Are you covering for McKinnon, or is that a part of your law firm?
Part of our law firm, Your Honor.
All right. So at this time, based on the fail to appear, Mr. Sarhan, for the motion to set aside the dismissal, how would you like to proceed? I do not believe Ogletree. There's a representative, Ms. Smith, and Ogletree is not here. Miss Hart, you're here on another matter. You're here on 24-03-134. Is that correct?
That is correct, Your Honor.
All right, thank you. All right, so Mr. Sarhan, how would you like to proceed today? It appears that the defendant is not here.
Yeah, Your Honor, I think the best course of action would be, of course, to vacate the dismissal and just to reinstate the case and maybe set it for a pretrial,
Okay.
just to get notice out to both Attorney Ogletree and the defendant, just in case there's some confusion at the current time as to whether or not she still has representation.
Yeah, I don't know. I'm going to grant the motion to set aside the dismissal, the previous dismissal that was done by the court for failure to appear on both parties. So I'll grant your motion, Mr. Sarhan, and we will reset for a pretrial on the matter, a general civil pretrial. And I'm going to make a note that notice should be sent to not only the defendant, but also the listed defendant's attorney.
Thank you, Your Honor.
I agree with you. I don't know that Ms. Ogletree is still on the case, but I will send it both to the defendant and the listed defendant's attorney.
Thank you.
October 23rd at 8:30.
So we'll set it for October 23rd at 8:30. And you'll follow that up with an order moving to set aside the dismissal, Mr. Sarhan?
Yes, Your Honor. And just to confirm, that next hearing will be by Zoom?
Yes, that's a Zoom appropriate hearing on October 23rd at 8:30. And I placed a note to send notice both to the defendant and the defendant's attorney.
Very good. Thank you, Your Honor.
All right. Anything else for the record in docket 23-02536, Mr. Sarhan?
Not for plaintiff, no.
All right. You're all set. Thank you for your appearance today.
Thank you.
All right. So, Ms. Hart, let's call your case.
Thank you, Your Honor.
Let's go Riverfront. So we're on the record in docket 2403134. This is Riverfront Apartments versus Alan O'Neill. Will the parties please introduce themselves for the record?
Good afternoon, Your Honor. Oh, I
Ms. Hart.
apologize. I apologize,
ahead.
Your Honor. Jumped the gun there. Sumchit Hart, P69542, on behalf of Riverfront Apartments.
All right, this is a motion to set aside the judgment and was based on the 3 days from judgment under the court rule. I know, so that's why we're here today, because Mr. O'Neill filed the motion indicating that he's filing it with 3 days, which is his right to do pursuant to the court rule. I had some questions to him concerning this matter, and it appears that this was set for 1:30. So I will indicate it was set for 1:30. It is now 1:57. And the defendant has failed to appear for their own motion. This would be Mr. O'Neill's motion. Is that correct, Ms. Cox?
Ms. Hart, yes, Your Honor.
Ms. Hart.
This is the defendant's motion to set aside the consent judgment. However, Your Honor, defendant has failed to appear. I'd ask for that motion to be denied.
Okay. Now, I know that when the defendant was given his notice for the motion, as he filled it out, the bottom has the time and place per person that he receives from the court clerk, indicating that this is the date and time for his motion to set aside the judgment. I went and looked at that, and the only thing I noticed is to his motion. So I'm going to say that for the record. Let me add that note. Yes, is that when he filed the motion, there was an indication that there was some indication in the motion that he may be going through a medical issue, but there was nothing in regards to the date and time of the medical issue. There was nothing in regards to that he couldn't make this hearing or motion, that this was an improper time or conflict. There was nothing along those lines in the motion. And when he was given the motion by the court clerk, there was no indication that this was a improper time and place. So I want to place that on the record, just because if Mr. O'Neill comes and says that he was otherwise not able to come, and that he's setting it aside once again, there's no knowledge of that. Our office wasn't contacted. And I would seek medical documentation on some level for that non-appearance today. But I simply have no reason why there's a non-appearance today at this time. With that understanding, I'm going to grant the motion. I'm sorry. I'm going to grant the motion I'm going to deny the motion to set aside the dismissal.
Thank you, Your Honor.
I'm going to deny the motion to set aside the dismissal, and it's based on clearly the defendant's non-appearance.
Thank you, Your Honor. And just to be clear for the record, Your Honor, it would be a denial of the motion to set aside the consent judgment, correct? So the consent judgment, which was entered on August 27th, still stands.
Correct. The
Excellent.
consent
Thank
judgment still, that was the original judgment. Consent judgment still stands.
Excellent.
And Ms. Hart, you're here, so you'll do an order denying the motion to set aside the consent judgment?
Absolutely, Judge.
All right. So we don't have any confusion on that. Anything else for the record in docket 2403134? 403-134, Ms. Hart.
No, thank you, Your Honor.
All right, you're all set. Thank you for your appearance
Excellent.
today.
Have a great afternoon. Bye-bye.
You too.
I'm not really sure why Mr. Smith left because he's got a subpoena personally served proof of service filed on the 6th of this month.
I see that.
So I don't-
Mr. Schneider, you can come up here.
Thank you, Your Honor.
That was Riverfront.
Left side?
You are the moving party. You can go on the side closest to the jury.
Okay.
So that should be fine.
Have you seated?
You may.
Oh, thank you.
All right, this is the time and set for, and so just so there's no mistaking here, but this was the time set originally. I signed an order sending this to mediation. Is that a fair statement?
Yes, Your Honor.
And then and it appears that a mediation was not scheduled in this matter. So there was an order for mediation, and then we received a notice from the Resolution Services of Center as of September 9th that no mediation was ever scheduled by yourself or Mr. Musa. Why don't you tell me about that, Mr. Schneider?
So the day of the mediation, Your Honor, my fiance suffered a miscarriage. So we called and rescheduled. And then their next available date was like a Wednesday or Thursday last week. So we attempted to schedule it for either one of those days, but I guess Glenn Musa was unavailable to accommodate those days from what I was led to believe. So then following into this week, obviously there was just no mediation. So we just decided to go through with the court.
All right, and so you both see, because the notice that was sent is sent from September 12th, 2024 at 1:30, but the parties must contact the Resolution Services Center of Central Michigan. What I'm concerned about, and Mr. Moose is not here, and we don't have. There's an June 5th indication that a bench trial has been scheduled for September 12th at 1:30 in front of myself. But it came with the order of mediation to schedule on September 12th at 1:30. That's my concern. I'm going to default somebody, and I want to make sure that everybody has notice because we've changed it from mediation to bench trial. Okay, and that's a little bit of a change because that means that Mr. Schneider, you're here and you should bring in all your evidence, and Mr. Musa should bring all his evidence, but Mr. Musa is not here today. So Mr. Did you have any indication from Mr. Musa? What my thought process is here is to set it for formal hearing for both parties. Okay, to set it for formal hearing, with the understanding that if Mr. Musa doesn't show up again, he's defaulted. It's out. There's also an evaluation form, since this was originally set for mediation for both of you to fill out, which indicates all your rights in the matter. Okay. Was this originally a small claims case, or was this filed in district court?
Small claims.
So it came from small claims. So it's an appeal from a small claims decision.
Okay.
That was done by the Magistrate Milmore. Is that correct?
Yes, sir.
All right.
Your Honor, I apologize.
It was filed for 25,000.
All right. That places it over the magistrate amount. Let's see. Let me look at it. Because my last note was all parties appeared to fill out pretrial form and scan, which would place it out of the. Let me see.
It's like, yeah, you had a pretrial in 63. That happened. You also entered formal judgment.
Let me see. This appears to be filed in district court. This doesn't seem to be on appeal.
I apologize, Your Honor.
Yeah, this does not seem to be on appeal from, and that's my concern is that I can't treat it like it's an appeal from mediation. I have to treat it like it's a lawsuit in district court. And if that's the case, then we should provide a full discovery. And I do notice that because we did fill out a pretrial form last time. Let's see if I can find that.
And then, yeah, then they set the bench trial and the bail notices on the fifth along with the mediation.
Right, that's,
Yeah.
I think that's. Let me see what the complaint is. Oh, this is, okay. Have you heard from Mr. Musa since the mediation or any of those items? All right.
Not at all, Your Honor.
Have you filed a complaint with the Lansing Police Department?
Not, Your Honor.
That may be somewhere. You're alleging right now that he was supposed to do work and he never did the work?
He did do the work, Your Honor. He just did it extremely poorly.
All right. So there's a dispute as to the amount. All right.
Yes, Your Honor.
All right. Let's go ahead and do this. Let's nobody's played for a jury trial yet, and I do not see and I know we did that, but it's not. Let's see. We filled out a pretrial form and scanned it unless, and the mediator should be contacted and discovery set. Let's reset this, all right? Let's reset this, and then if Mr. Musa doesn't show up, I have my answer, okay? Neither party is represented by counsel today, and I'm gonna set it fairly in a reasonable time because I want to make sure everybody has their evidence together because that's what you're going to be showing the court, okay? And so make sure you bring in any photos, any documents you have, anything, all right? And then Mr. Musa should do the same if he has it in order for me to make a decision on the merits of the case. But I'm gonna, because there was a mediation scheduled and then it never happened, and this is not a mediation, this is not a case that comes from small claims. I want to treat it as if we have lawyers involved, and that means we set it through the discovery process. So I'm going to reset it. But if Mr. Musa doesn't show up, then we have our answer. Okay.
Understand.
What essentially happen is you'll get a default order. All right. So let's reset this for bench trial. And everybody should get notice of the.
How far out?
Let's see. That's a great question. Let me.
Do you need to do a discovery? Or is that-
Some of it's been done. Some of it, I don't know if it's been done. So, and I know the parties are not represented, so they're not speaking to one another. So I kind of want to get it. I probably get it in here in the next 30 days. If we
You want
have,
to do October 23rd then?
yeah, let's do that. And
9:30.
then Mr. Musa, check with your schedule because you're here today. So if there's some flexibility, you get the flexibility. All right. All right, because Mr. Musa is not here, so he doesn't get to, but if that works with your schedule, that's fine. If not, we can find another date. You may want to talk to.
Should be fine. Right. Okay. Yep, that's totally fine, Your Honor.
All right, let me get out of. I'm going to give you your notice here.
Thank you very much.
And part of this is because you're kind of caught between small claims and district court because there are no lawyers and no lawyers are usually associated with small claims and appeal from that small claims court. But this is over that monetary amount.
Mhm.
So what we're going to do is we'll reset for an actual jury bench trial. It'll be in front of myself.
Mhm.
And then if Mr. Musa does not show up, we kind of have our answer. If he does show up, he'll get a bench trial notice and he should come with whatever evidence he chooses to come with, all right?
Understandably. Your
All
Honor.
right, so when did we reset that for?
October 23rd at 9:30.
October.
May I ask the question, Your Honor?
Sure.
Is it possible to add my fiance also, because she's been instrumental in organizing everything, so she's also very familiar with this case and all the discovery? Is it possible to also add her to this, I guess, so she can, I guess, help?
You can make an oral motion to amend, adding her to the plaintiffs. So it'd be David Schneider and your fiance. And then you're probably going to call her as a witness if she's been, yeah, if she's been through the proceeding. But you can make an oral motion. What it's going to really require is something in writing. So you might want to go down to the civil department and ask them, how do I add as a plaintiff this name to it? I can say yes, it's orally granted, but that doesn't mean anything until I sign something. And so I'll say, yeah, an oral motion was made by plaintiff to add, and I don't, and with Mr. Musa not here, we can do that. Oral motion to add, and what's your name, ma'am?
Tessa Rademeyer. I can spell my last name.
You'll probably have to spell both names.
TESSA
Okay.
ROE
ROE.
THEMEYER.
All right. I will orally grant the motion, but what you're gonna have to do is go down and say, how do I get her on the plaintiff on this? Because it won't take effect till I sign an order. And I'll have to sign an order to that effect. And that is usually an amendment of the complaint that you're indicating that will add a party to the plaintiff, and you can do that. All right. There's just a process. The bench trial is set for October 23rd. And there was a moral motion to add a plaintiff. I'll make a note of that. And then I will leave it to your wherewithal to go down to the floor and figure and say, how do I do this? How do I add it? What paperwork do I need to present to the judge? Because I told the judge that I'd like to add this person to the plaintiff, and the judge, and they'll say he needs an order, and that only comes through an order that I sign. All right.
Sounds good.
So that'll be on October 23rd at 9:30. We're setting it for full trial on that date. If my office hears from Mr. Musa, we'll tell him the same. If we don't, we'll just go to that date. And if he fails to appear on that date, then you can request a default in this matter. Okay.
Understandable. Your Honor.
All right.
Thank you.
Anything else for the record in docket 2400151, Mr. Schneider?
Not that I can think of right now.
Okay, you're all set. You should have the notice. Thank you for your appearance today.
Of course. Thank you, Your Honor. Have a good day.
You too.
Thank you.
Interested to see if Mr. Musa shows up next time.
Wonder what kind of job he did.
Yeah, I think we have our answer, but I want to treat this
Yeah.
like a regular because they're asking for a lot of money.
Yeah. $25,000 is a lot of money.
Yeah, that's a lot of money.
Well, that's our limit.
Even for our lowly district court. Sir, sir or ma'am, on the One Plus CPH 2515, would you please identify yourself? You just joined the courtroom. And you'll have to unmute. One Plus CPH 2515. You just joined the courtroom and you'll have to unmute. If you don't identify yourself, we'll have to place you in a waiting room until we can get an identification for you. You'll have to unmute at this time. All right, all right. What's your name?
Sharon Vaughn. I have a 2:30 appointment.
All right. So, Ms. Vaughn, you're here for your 2:30 with Discover Bank. Is that correct?
Yes.
All right. You stand by. You're in the right place. We're going to rename you. So we have your actual moniker, and then we will wait for Discover Bank's representative. All right.
Okie dokie.
All right. Thank you.
All right.
Okay, Attorney Patillo, you're here for Taylor Dixon. Is that correct?
Yes.
All right. You stand by. You're in the right place, and we'll get a representative from Discover Bank when they show up. That's scheduled for 2:30. All right, ma'am.
Okay, thank you.
Thank you. All right, Miss Kelly, are you here for Discover Bank?
Yes, good afternoon. I'm here on behalf of Discover Bank in 3 matters, actually.
All right. I have 2 matters. I have all 3 matters, so you're in the right place. I lost somebody. Oh, no. I have an attorney for Taylor Dixon. I have Ms. Patillo here. Would you like to talk to her before the pretrial in order to discuss this matter at all?
I would, thank you. And if the other parties
All right.
become available for breakout rooms, I'd like turns with them as well.
All right. Ms. Vaughn is not represented. That would be the second person. And then Ms. Roberts is not here yet. So that would be the third case. But I have Ms. Patillo here for Ms. Dixon, and I can place you both in a breakout room. Ms. Patillo, would you be amenable to speaking with Ms. Kelly in a breakout room?
Yes, thank you.
All right. All right. I'm going to have Ms. Patillo placed in room 1. You should get a prompt to go to room 1. And then Ms. Kelly, you'll also get a prompt to go to room 1.
Thank you.
You're welcome.
I think it's interesting. Court, even within their own JIS.
Oh, yeah.
Why are you guys setting that? That doesn't make sense.
I let the parties talk on anything because
Oh, no,
generally,
I jumped off that.
yeah.
I was
But-
I'm back onto your personal rule of evidence
Yeah.
thing, and when you said how they can be 2 separate. And I get that in 2 separate states, but I'm saying within the same
Oh, yeah.
counties, how we run different.
Well, you could do so in the same court. I mean, I practiced in circuit court, and a ruling was made on one case. You go next door, and you'd have exactly the opposite ruling between the 2 judges. They just analyzed it different. They were completely different. That doesn't make it easy because it doesn't make it easy for consistency as a practitioner. But you have to expect it. You have to expect that they're going to analyze the rules different. And it's the same rule. So, I mean, get ready for plan B. That's the rule. The rule as I learned in practice is there's always a plan B. Whether you agree or not, act like you know exactly what they're going to do and keep going. You know, be respectful, but if you disagree, there are avenues for that. But you should always have a plan B ready. Because this is one thing we used to do, and you know this is a practitioner, but it's hard if you're just teaching school.
Yeah.
You as a practitioner, I would do with my competition teams, we would do a trial in which I would rule against them in everything. I would just rule again, whether I was wrong or right, I would just rule against
them to see what
Just
their
to see
argument was.
to see if they acted correctly,
Yeah.
to see if they responded correctly, to see if they had a plan B. You got to have a plan B because you don't know what the judge is going to rule. The judge might rule just to see if you have a plan, and you need to consider all of it, but you must always be respectful because you're getting point valued on being respectful. The students hated that day. They hated it. I would tell. I do one. We do one trial where I literally flip a coin for the decision. I do it in front of them. Heads was yes, tails was no, and I'd flip and I'd say heads. So you're overruled at this point. And you could tell that they had built their whole case around 2 exhibits. Have a plan B.
Have a plan B.
Have a plan B.
So that is actually, I could see where that could be so helpful because I see a lot of new attorneys. To me, that's just me just watching. They have the inability to think outside the box.
No, they get stuck in. Of course, this will happen, so this will happen. Well, if A doesn't happen, then B is not happening. So you better have a rule. You better have a plan.
And that throws them
off.
It
does.
And if it doesn't go like let's say these are my question sets for my PE. If something gets thrown off there, their whole game is thrown off.
Yeah.
They are not, and I just don't think it's attorneys. I think a lot of it is that generation does not have the ability to find the gray or look about. Everything has to be black and white.
Right. Well, it takes time to find yourself in a courtroom. It takes it takes a year or two to really find yourself in a courtroom. But this is the kind of thing you're thinking of. This is the kind of thing you're thinking of. You'll have all your questions written down, and you'll say, "Okay, please state your name and spell your last name for the record." And they'll say, "My name is A.B. and I spell my last name, and I work for the Lansing Police Department." The next question, not listening, is
where do you work?
Where do you work?
Yeah.
And they just said that.
Yeah.
So what you've told them is you're not listening to them.
Right.
So don't do that. Don't listen and then act accordingly. You know, cross off the questions that are meaningless and act accordingly. But
I totally agree.
People don't, lawyers got to find their way too. It's part of the deal. All right. So let's go ahead and call that case. So that is 24-03097.
Oh, the system. Oh, no, we're good.
Okay. So we're struggling with technology today. So and that's to be expected. So we're on the record in docket 24-03097. Will the parties please introduce themselves for the record, Ms. Kelly?
Yes, good afternoon. Jessica Kelly on behalf of Discover Bank through the firm Buckles and Buckles.
And Ms. Patillo.
Good afternoon, Your Honor. Deanne Patillo on behalf of Taylor Dixon, and I'm standing in for the attorney of record, Gilbert Borman.
All right, this is the time set for pretrial in the matter, and both parties had the opportunity to speak in a breakout room. Ms. Kelly, how are we proceeding today on this matter?
Yes, thank you for that opportunity. We were able to discuss some options, but of course, we will both need to get some authorization from our respective clients to go forward. And so at this time, I believe Ms. Patillo and I agree that what we need is a date set in the future to ensure those conversations happen with hopes of resolution.
All right. And so did you want an adjourned, because we can set this. I don't know if you were going to do a pretrial statement involved so that, or if you wanted the court to do it, we have a pretrial statement that we can fill out. But since both parties are represented, I can think that we could wait 30 days and do it at that. Then we'll just adjourn the whole pretrial proceeding so that the parties can go back and seek authority from their clients to see if this matter can be worked out. Is that a fair statement, Ms. Kelly?
Yes, that would be fine with me.
All right, Ms. Patillo, is that where we're heading, at least for some negotiations before we actually fill out a pretrial statement, which will indicate the discovery of 90 days and anything of all those terms?
Yes, Your Honor, that sounds great.
All right, so let's set for an adjourned pretrial for negotiations to continue. And I'll give you, let's get a date 30 days out, I think.
It's going to be October 23rd at 8:30.
October 23rd at 8:30.
Thank you.
And that, of course, would be Zoom is appropriate for attendance purposes.
Yep.
Yes.
All right. Anything else for the record in docket 24-03097, Ms. Kelly?
Not for the plaintiff. Thank you.
Ms. Patillo, you're all set today?
All set for defense, Your Honor. Thank you.
All right. Thank you. All right. So, Ms. Kelly, we also have Ms. Vaughn here. You're all set, Ms. Patillo. Thank you for your appearance.
Thank you. Have a good day.
You too. Okay. And Ms. Vaughn, you can unmute. So Sharon Vaughn, you can unmute. So it's usually the microphone. I know because I heard you before, and then you were placed on mute status. There you go.
All right.
Ms. Vaughn, would you be, Ms. Kelly is here from Discover Bank. Would you be amenable to speaking with Ms. Kelly in a breakout room before we start the pretrial hearing?
Yes, I could do that. Yeah.
All right, Ms. Kelly, you wanted, so Ms. Kelly, you can go back to room 1. You can rejoin room 1 when you're already there. Or I can go ahead and give you a prompt to go to room 2.
I think I can rejoin. If I don't disappear, I'll need the prompt.
All right.
Thank
All
you.
right. So, and then Miss Vaughn, I'm going to put you in room 1,
Okay,
and you'll get a prompt to go to room 1.
okay. Okay, I'm back.
Very good.
All right, so we're on the record in docket 2403097. I'm sorry, 2403261.
Yeah.
0240621. That's people of the state of Michigan. That's Dixon Bank versus Sharon Vaughn. Appearances for the record, Miss Kelly.
Thank you. Jessica Kelly, and a small correction. I'm here on behalf of Discover Bank through the firm Buckles and Buckles.
All right, thank you. And then, ma'am, you are Sharon Vaughn, is that correct?
Correct.
All right. This is the time set for a pretrial in the matter. And I'm going to indicate for the record that the parties did have the opportunity to meet together in a breakout room prior to the pretrial. Ms. Kelly, how are we proceeding today?
Thank you for the time with Ms. Vaughn in the breakout room. We did have an opportunity to share some options, but unfortunately we weren't at a place where we could choose any one of them to put on the record today. We essentially agreed it's not a matter of what is owed, but how it will be repaid. So what we're asking for today is to have another hearing date set. A trial date would be fine, set into the future to give us enough time to reflect on our options. Hopefully we will be able to settle, but at least we'll have that date to keep us moving forward if not.
All right, so we will adjourn this date before we get the pretrial statement and discovery all set as we did in the last hearing, in the last case. So Ms. Vaughn, you were able to share some of the information, and we have the nature of the issue. The next time we meet, we may fill out a pretrial sheet in order to start setting discovery times, discovery positions, and the issues at hand. But I do think that this is a positive step in resolving the case, and so we'll set for pretrial on.
How far out?
I'd say 30 days. Is that fair, Ms. Kelly?
Okay,
30 days is fine, yes.
pick a different day. You're getting quite filled at your civil day. Thursday, October 24th at 1:30.
Perfect.
October
So
24th.
yeah, well, you should get notice sent to the last known updated address with the court. It'll be set for October 24th at 1:30, and that via Zoom is acceptable on that date.
Okay.
If we're not able to resolve the matter, we will fill out a pretrial statement at that time for the parties, but that should give the parties some time to continue negotiations and talk. Anything else for the record in docket 2403261, Ms. Kelly?
No, not from the plaintiff. Thank you.
Ms. Vaughn, do you have any questions of me?
Nope. I'm all set.
All right. Thank you for your appearance, Ms. Vaughn. And Ms. Kelly, we can call your next case, which I think is a fail to appear.
Okay.
Okay.
It's Mr. Roberts.
So how do I?
So we're on the record in docket 24. So Ms. Vaughn, you're all set. Thank you for your appearance today.
Okay, thank you so much. I was trying to figure out
And
how
we're
to.
on the record in docket 2403269. That is Discover Bank versus Katera Roberts. Will the parties please introduce themselves for the record? Ms. Kelly.
Good afternoon, Jessica Kelly on behalf of Discover Bank through the firm Buckles and Buckles.
Thank you. This is the time set for a pretrial in the matter. It was set for 2:30. It is now 2:49. So it would appear that the defendant has failed to appear for the pretrial conference. Now I'll indicate that it was set for 2:30 and it is now 2:49. Ms. Kelly, how would you like to proceed today?
Thank you, Your Honor. The complaint has been filed and an answer was received that did not deny the complaint or assert any affirmative defenses. So between that and the defendant's failure to appear today, the plaintiff would be asking for a default judgment. And I can read you.
Do you want to place any terms on the record?
Yes, I'm happy to read the total judgment amount. That would be a total judgment amount of $1,890.01, which is inclusive of filing and service costs.
Okay. And you'll follow up with an order to that effect, Ms. Kelly?
If it's not already in the court's papers, because I know that sometimes it is sent along with the original complaint, then we would be happy
right.
to complete it and send it your way.
All right, if it's not already signed, the court will require a Michigan electronic filing. It could be a part of the court papers, but if it's not, I'll await to sign that, and I'll orally grant your default judgment.
Thank you, Your Honor.
All right, anything else for the record in 2403269, Ms. Kelly?
No, not from the plaintiff.
All right, thank you. You're all set, ma'am. Thank you for your appearance today.
Thank you. Have a good afternoon.
You too. All right, so we're on the record in docket 1300069. That's Lansing Automakers versus Theron Jones. And it would appear today that Mr. Smith was here previously on the case right after this. And this for discovery, this was set for discovery. Mr. Smith was on the case right after this. He left the room. I don't know if it was not on the docket, but we're going to reset for discovery purposes, and then we'll get a new notice set out to Lansing Automakers and Theron Jones, and the civil department can reset the hearing for discovery. That's all for the record in 1300069.